my guess. All right, Mr. Fairlow, you got what you need? All right.
469C, Your Honor.
Yes.
All right. Is this another chart that would be generated by the microspectrophotometer?
Yes, it is.
Okay. Can you tell us, with respect to the results depicted in this chart, whether or not you would conclude that the two fibers measured by that instrument would be determined to have had the same origin?
Well, I don't know if I'd use the term measured, but yes.
Whatever term you like.
All right. When one fiber was tested, it produced a curve, like you see, let's say the top curve. The second fiber produced the bottom curve. And what an examiner looks for is to see if there's conformity at the specific absorption peaks and transmission peaks. In this particular case, they do conform. This particular test was taken from the same fabric, which shows you another thing, that they don't have to lay one right on top of the other. That they will absorb dye differently. So you have to look at how the curves appear, not if they lay on top of one another.
Okay. So in this case, the two blue fibers, they were actually picked off from the same material.
Actually came off the same yarn.
We have
So the
many,
fact
many
that-
yarn experts.
I'm sorry, Your Honor?
We have many yarn experts.
Yeah, that's right. And if we measured their yarn, it would, and you would try to follow the same peaks and valleys, and that's how you would determine whether or not it had the same origin.
Same peaks and valley comparison, yes.
Is there anything that will produce a different peak and any kind of additive? For example, if a piece of yarn, if you have two pieces of yarn from the same ball, same origin, one piece has a little bit of blood on it, the other one doesn't. Is that going to cause some difference in the result on a chart like this?
It will. It'll pick up the color, just not knowing any different. It'll absorb in that particular region of the spectrum.
Is there any way to account for that in determining whether or not two fibers could have had the same origin, so that you don't improperly exclude it because of the blood?
Well, you could test a test sample of the fabric and add blood to it to see the effect of blood to that particular known sample, or you could clean off the blood and see it without the blood present. The blood peak is pretty easy to see, and once you see it with the microspectrophotometer on the chart, you can infer that.
Is that a pretty common issue in criminal cases?
Well, in criminal cases often involve bloodshed, and clothing fibers often pick up blood. The question fibers that you look at may have blood on them. The known standards that are taken routinely are not. You don't try to take known standards from the bloody area. Try to take it from a clean area, but you may have to take it from the bloody area just to show the comparison. But we're talking a real small piece of fiber, though, and the blood. You're talking about a very small area of the fiber that you're actually testing. But you can pick up an absorption in that particular if it has blood on it.
All right, so let's assume for a moment that in your comparison of the natural fibers, you've done the comparison on the comparison scope, and they seem to have the same characteristics. You go to the microspectrophotometer, and you produce wavelengths that have the same characteristics, peaks and valleys. Is there some further step you can take?
Yes, there is.
And what is that?
Fluorescence. Fluorescence microscopy can be used.
You want to mark this
470?
469?
470, Your Honor?
470?
Yes, thank you, Your Honor. This is the fluorescent microscope?
Yes, it is. It's again a comparison microscope, which has fluorescent cubes in the uppermost portion of it, and they can be altered. A specific type of light is reflected off of the surface of the fiber, and if the fiber has fluorescent qualities, that is, it will absorb certain wavelengths and also emit a longer wavelength. It may appear to be a different color to the eye under different lighting conditions. We use ultraviolet light, blue light, and green light. And comparison is made between the question and known the same way. If the question fiber and the known fiber fluoresce the same, and they are the same in all the other tests that are conducted, it's just another confirmation. Where you might have problems with it, you go through the steps and you find that they are all very similar, but the fluorescence is wrong. And that might be a way to eliminate that fiber as possibly coming from a particular garment.
Okay, so if you're trying to determine whether or not a questioned fiber and a known fiber could have had the same origin, when you subject them to, say, did you say green light, for example, you might use?
Yeah, a green light.
A green light under the fluorescent microscope, they should fluoresce the same way?
They should, right, if they fluoresce, they should fluoresce the same. The color that you're looking at visually should be the same.
And if it doesn't,
They may
then,
not fluoresce. I mean, some fibers just don't fluoresce at any wavelength.
okay, but if one does, if the question fiber fluoresces under the green light
Right.
and the known fiber does not fluoresce under the green light, what conclusion, if any, would you draw?
Well, there's two possible. One, that they came from different fabrics, and two, something happened to the one that the other, it didn't happen to the, for instance, you may have some time factor. You may have the fiber laying out in the sunlight for a long time and losing its fluorescent qualities, their ability. It gets faded. It leaches out whatever ability that fiber had to fluoresce. The known fabric was retained and wasn't affected the same way. You might find that the question fiber doesn't fluoresce, yet the known fabric still does. So then it's a matter of maybe doing some tests, taking some of the known fibers, letting them out in the sun for a while, same period of time, and then seeing if they act the same way.
So would you ever call an exclusion, that is, determine that a question fiber and known fiber could not have had the same source based solely on what you see under the fluorescent microscope?
You could. It depends on the circumstances, the historical information that might be available about a fabric. I've done it before.
Now, so far, the steps that we've gone through, are these steps that you can do for both man-made and natural fibers?
Yes.
After the fluorescent microscope stage, is there some further step that you could take natural fibers?
With synthetic fibers?
No, natural fibers. Can you go any farther in your analysis?
Oh,
than this
there's
with
other
natural?
tests you could use. Sure, you could strip the dye using thin layer chromatography and do a dye separation. There's a number of other tests that could be used.
Are they routinely used?
Well, in some laboratories they are. We don't use thin layer chromatography routinely in our lab. It's a destructive technique. In some instances we might use it depending on the circumstances. You have to have a lot of known standard to work with. That is enough so you can determine the system that you might want to use, because you have to take the dye out of the fiber and then you have to see how it can separate on a chromatographic plate. So you need enough to work with to experiment, to see if you only have one fiber found on the victim's clothes, but you have a lot of fibers from the suspect. You want to make sure that if you're going to do anything to this question fiber, that you better know the results you might expect to get. Because once you take the dye out of the fiber, you've destroyed it.
Okay, that's thin layer chromatography.
Right.
Now, the processes that you've outlined for us so far, are any of these destructive processes?
The ones that we use are not destructive.
So that when you complete all of the steps that you use at the FBI, is the hair or fiber intact as you found it?
Yes, it is.
All right, now for man-made fibers, can you go farther than fluorescent microscope and thin layer chromatography?
Yes, you can use FTIR, infrared spectroscopy.
People's 471, Your Honor?
471.
So after all the steps you've gone through, everything looks the same, and you come to FTIR. What does that stand for?
Well, I'll probably really murder this one, but it's a Fourier transform infrared spectroscopy. Fourier spelled like F-O-U-R-I-E-R. I apologize.
Transfer?
I apologize to these people who know more about it.
We'll say FTIR.
FTIR is beautiful.
Okay, what does it do?
Well, the instrument that we have has a microscope attachment. A small portion of the fiber is flattened. It's actually a roller is applied to it and make a thin layer of the fiber, and then passing infrared light through it. It will again absorb and it will affect. It will affect based on the polymer that's in that particular fiber. The molecules that make up the fiber interact with the infrared light. They start shaking and vibrating in all directions, and this shaking and vibrating allows a chart to be prepared. And this chart will identify the polymer and also can be useful for a comparison.
Okay, let's pull up the chart and tell us how it can be useful for a comparison as well as the identification of a polymer. Actually, before we do all that, what's a polymer?
A polymer, could be a man-made fiber, as an example. It's a long chain synthetic material, man-made material, made up of a lot of smaller components. Could be called monomers, and a lot of them are poly, so it's polymer. You might start with some small building block, and you make a lot of it, a long chain of it. And that's what makes up a particular fiber. Different building blocks make up different materials.
Okay.
A nylon material is different than a polyester material.
So when you say identification of the polymer, you're telling us that when you identify the polymer, you're identifying whether the man-made fiber is rayon or nylon, that sort of thing?
Or nylon 6 or nylon 6,6 or nylon 11. Depends on the type. There are different types of nylons, and there's different types of acrylics, and there's different types of polyesters. And this instrument can be a little bit more specific. Whereas I can say it appears to be a nylon fiber based on my test. This could tell me it's a nylon 6,6 fiber.
So then, after the molecules are all shaken up, a chart is produced,
A chart is produced.
which measures what?
Well, then again, you're kind of going into the field of FTIR that perhaps I'm not most expert at. But it gives a chart of the reaction of the infrared light through that material.
Your Honor, may this chart be marked People's 471A?
471A.
And is this an example of a chart that would be produced by the FTIR?
Yes, it is.
Tell us what it shows.
Well, this particular chart is indicative of a nylon 6,6 chart. And that's based upon a comparison with a database of spectra of nylons. By comparing that spectra that's produced with known standards, that particular polymer can be identified. It's useful also from the standpoint of comparison, because dye components, coloration, anything that's added to the fiber will also interact with the infrared radiation that's hitting the particular fiber. So that you may have dye peaks that may not be characteristic of an undyed fiber. So it can be useful for comparison as well, besides identification.
In which case you would be comparing the different peaks for each fiber?
The position, yes, the position of the peaks in relationship to each other. Question and known.
Now this just reflects one fiber's measurement?
One fiber.
I think you spoke earlier about the cross-section of a fiber on one of the charts. Is that something that you routinely compare, the cross-sections of fibers?
Yes, it's a very excellent way of comparing fibers.
And what is a cross-section of a fiber?
Well, cross-section is how it looks if you look down the end of it. Like if you lopped off a tree, you know it's round. Well, you lop off a fiber, you know what shape it is.
Can you always see the cross-section of a fiber without cutting it?
Sometimes you can. Sometimes you can. The more intricate the cross-section or the more unusual the cross-section may require using a sectioning technique. It's a manual technique, which you can do right in the unit. Or you might take it to a scanning electron microscope, and there's a technique that can be used there, which will allow a different type of section and a different type of look.
Okay, on the chart concerning fibers that we saw before, you pointed out the trilobal look, and then the one that had the 4 holes in it like a die, like dice.
Right.
Okay, were those examples of cross-sections?
Those are examples of cross-sections, yes.
Okay, now what is the scanning electron microscope that you said could be used in connection with the examination of cross-sections?
Well, the scanning electron microscope actually passes a beam of electrons striking the surface of a material, and then it is detected. The material, the reflection of those electrons onto a detector will give you an image, a three-dimensional image of what you're looking at.
And did you furnish some photographs to be shown to the jury of an example of the kind of photographs that are taken by the scanning electron microscope?
I did.
People's 472, Your Honor?
472.
Tell us what this is, sir.
This is a nylon fiber.
Your Honor, may we approach?
Yes.
For what possible reason is so controversial that we need a sidebar about this fiber? For what possible?
Proceed.
Proceed.
Okay, well, this was 472. Please tell us what this is.
It's a regular trilobal fiber.
What does that mean?
Well, the 3 lobes of the fiber are uniform in length and appearance.
Meaning that no one curve is longer or different than the other two?
Well, that's what that means, yes.
And is that a photograph taken from the scanning electron microscope?
It is, yes.
And what does this fiber come from?
Sustain. Sustain. Just what type of fiber is it?
What type of fiber is this?
It's a nylon automotive fiber.
Proceed.
Okay. Next. What's that? May I make this, sorry, Your Honor, 473?
473.
This is a nylon automotive fiber of a different cross-section.
Okay, this looks different. How's it?
Well, it's different from the standpoint of appearance. That is, I call it the jack cross-section. It has, if you had toys as a child, some of you may not be old enough, but jacks had the little knobby ends on them with a little ball and your jacks. Well, anyway, I call it the jack cross-section. But it has 3 lobes, little knobs on the end of them, and it's a little bit unusual. It's different. It's, again, another automotive fiber.
What's that?
Well, it's called the Michelin Man. I didn't label this one, but it's the same, essentially the same fiber as the previous one, as 2 components made by the same company, but they changed the cross-section of it, and it appears differently. This, again, is another automotive nylon fiber made by the same company.
People's 474, Your Honor.
Somewhere.
Okay, so were all 3 of these, 472, 473, and 474, scanning electron microscope pictures?
They were.
And all of them were taken of a nylon carpet fiber from an automobile.
They were.
And by the same manufacturer?
All by the same manufacturer.
Full roll at this point.
Were they taken from different years?
Sustained. Sustained.
All right, after all the tests are conducted with respect to comparison microscope, microspectrophotometer, fluorescent microscope, polarizing light, scanning electron microscope, FTIR, have I missed any?
I think you have them.
After all of that, what conclusions can be reached concerning the comparison of fibers?
Well, after all that, I can only say that the fiber could have originated from that fabric.
Could have?
Could have.
And when you draw that conclusion, what has to be similar? To what degree do you have to find similarity? Can you have any differences at all to reach that conclusion?
Can't be any significant differences. Anything you can't account for have to be all pretty much the same right down the line. All the tests, the original test and the confirming test, have to agree.
When you say no differences you can't account for, what does that mean?
Well, as I said, you may have run some tests initially that there may be something that comes up in the subsequent tests that you can't explain. You may need to get some information about the historical information about the fiber or the fabric or what happened to the suspect's clothes before they got the clothes. As an example, the suspect goes home, washes his clothes, uses an optical brightener, fab with borax or something, I don't know, but whatever. And the police get the clothing and they think that that's the clothing that he wore. The reaction of that particular fiber will be different using fluorescence, for instance. It may fluoresce, whereas the other fiber didn't. So you may have to do a test. You may have to get information. What happened to the clothes afterwards? Can we recreate the same situation? You might not be able to. It just depends. But for the most part, they'll conform all the way down the line when an association is made.
So you can't say that...
Your Honor.
Yes. Has to be stricken and disregarded.
I didn't hear.
Stricken and disregarded, the word match.
Oh, I didn't hear.
Not in this context.
So you cannot say that a particular fiber definitely came from this one piece of fabric and no other.
Oh, no.
You can't say that. Okay, but if you find that the fiber does exhibit the same characteristics, a question fiber, as a known sample of cloth, what is the likelihood of finding another fabric at random that has fibers exactly like those of the question fiber?
Objection.
Sustained. Foundation.
Okay, let me back up. What is the significance of a conclusion that a question fiber could have come from a given known sample of cloth or item of clothing?
There is a great deal of significance to certain fiber associations. Some are more common than others. That when you take, for instance, a man-made fiber of a particular type and you color it, you add color to it, it takes on a sort of a uniqueness. Now, it's a fact that the manufacturer is not going to make...
Excuse me, Your Honor. I object to sort of uniqueness. There are no degrees of unique, and unique would be
Sustained.
improper.
Speaking objection,
Jesus.
counsel. All right, I think we're going to quit at this point, though. All right, ladies and gentlemen, we're going to take a recess.
We're
at
going to
this point.
quit.
Hold on.
Mistrial.
We'll go over to
We're done.
Clark.
Everybody go home. Judge Ito doesn't want to do it anymore. He quit his job. He didn't quit his job. It was a joke.
Different matter. Earlier this week, it was brought to my attention that there was a certain book that a couple of you were reading, and some
John
concerns
Grisham.
were expressed to me about the content of that book, which is why I asked the bailiff to collect that in an abundance of caution. But I've thought about it, and that book is clearly a work of fiction, and you have promised me that you will decide this case based solely upon the evidence that is presented here in court.
Nice and
only
clear
upon
today,
and using the
Salty?
law as I instruct you, and I'll return these books to you. I apologize to
Oh,
you for the
you already
inconvenience, but
answered me.
I'd hate to have this case have something horrible happen for reasons that have nothing to do with the facts and the evidence. I'm sure you understand. And I'm sure you will follow my instructions to reach your verdict on this case solely on the facts, the law, and the evidence. All right? Remember all my other admonitions to you, however. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Don't conduct any deliberations till the matter has been submitted to you. I'll see you tomorrow morning at 9 o'clock. All right? As far as the jury is concerned, we'll stand in recess and we'll reconvene in 15 minutes. All right, back on the record in the Simpson matter. All parties are again present. The jury is not present. Counsel, let me just get rid of a few easy issues first. With regards to the use of the two photographs, there is apparently a first booking photograph of Mr. Simpson, which just does show him in a more benign attitude than what appears to be the, for lack of a better word, a more sinister visage. But the one that they've chosen to use, which they're entitled to do, I mean, it's their exhibit board, they're entitled to make it the way they want to. But they do so at their peril, since I'm sure that'll be part of the argument. All right, as to... Yes, you may. Mrs. Robertson. All right, I was a little concerned. The reason we stopped 2 or 3 minutes early is I was a little concerned where we were going with those electron microscope photographs in light of the court's ruling with regards to the report. Ms. Clark, do you want to let me know where we're going with that?
We had just about, that was about it. I think I had one last question. I was not going to elicit the fact that this was a Bronco carpet or the manufacturer manufactures Bronco carpets, because I think I'm pretty clear on that. I was simply going to ask if that was representative of different years, that the manufacturer changed the carpet type in different years. That's it. As far as that was going, then I believe the last objection, I didn't think that that would be objectionable. That's why the court probably saw me give a quizzical look. I didn't intend to go any farther than to indicate that the manufacturer did change over a period of years, and it's illustrative in nature, nothing more. And I thought that would be acceptable and within the parameters of the court's ruling.
Well, I thought it was illustrative of different types of fibers as they appear in electron microscope photography. And I thought that was about the extent of it, so I think you've covered it at this point.
Right, and I won't go back to that.
All right.
The question I think that elicited, or the answer that elicited the last objection, I don't understand counsel's objection. This is an expert. Perhaps I should lay some further foundation with respect to the number of fiber comparisons he has done, but I think I already have elicited the fact that he's done 500,000 comparisons in his 17 years, and some of, roughly half, or some of those were, they were both hair out
refresh my
fiber.
recollection as to which one we're talking about.
What question?
Yes.
I asked, after an objection by counsel, what is the significance of a conclusion that a questioned fiber could have come from a given known sample of cloth or item of clothing? Objection overruled. And then this is what the objection was focused on, is the following answer. There's a great deal of significance to certain fiber associations. Some are more common than others. Then when you take, for instance, a man-made fiber of a particular type and you color it, add color to it, it takes on sort of a uniqueness. Now, it is a fact that the manufacturer is going to make, and then there was an objection to the use of the term uniqueness.
Where are we going? Where are we going with this?
Just fibers. We're not talking about Bronco fibers. We're talking about in general the fact that, you know, all red fibers are not created equal. All black fibers are not created equal. And this witness has seen enough of those fibers to know. But we're just talking about fiber comparisons, Your Honor.
Please, the court, I think this witness is obviously much too intelligent to misuse the word unique accidentally. There is no such thing as sort of unique, pretty unique, or more unique. You're either unique or you're not. And if you're unique, you're in the match category. And I think that we ought to have some pretty firm rules about that. And I see everybody walking right up to the line. Automotive carpet fibers, years they were made. I thought these were the things that were not going to be mentioned. These were mere examples.
Yes, mere examples. All right. Ms. Clark, as to the, he can't testify to how differentiation is made between fibers. which includes colors, dyes, other examples of how one goes about talking to manufacturers and finding out from databases, that sort of thing. That goes to the technique. I don't know if you really want to do that since you're not going to be able to offer that.
Well, there's other fiber matches besides Bronco yarn.
Oh, I understand. See, but you fall into that. There are others that appear to be similar.
I'm sorry. Right.
Right.
But, well then,
No, I understand that.
okay. The other question I have is this. I understand the court's ruling with respect to not using any of the information in his testimony concerning the report from Maslin, but the witness is permitted to testify to his conclusion that was turned over to counsel, that he found, that he identified, he found the same microscopic characteristics in the Bronco fiber from the defendant's car as he did from the carpet fibers found on the Rockingham glove and knit cap.
That's correct.
Okay. And if the defense then opens up this area and says, well, there were tons of carpet
I don't know which I
made,
like better. I like her
then
hair
he
both
should be
ways.
permitted to answer that question rather than lie to the jury.
Well, if they're so foolhardy as to do that, but I suspect that the cross-examination will be all you can really say is it looks similar, correct, but you can't absolutely say it came from this source, can you? No, I can't. Thank you very much. Goodbye.
Okay.
Your Honor, very specific.
I should also indicate...
Because the shorter the cross-examination is, that gives the message to the trier of fact that who cares?
I wonder if that message was received. But let me ask you this, Your Honor. With respect to this expert's
But
opinion...
what I'm doing by saying that, though, is I agree with you. There's a possibility that if we get into commonality and that sort of thing, if they get into that area, that's a different story.
Okay, okay. Further, this witness, the reason he undertook the further inquiry to Maslin is that he found something unusual about those carpet fibers. And then, based on what he saw in them, in his experience, has nothing to do with Maslin. This is before that ever happened. In his experience, he looked at them and thought, this is unusual. He then looked for other items. He looked through other items and found the match to other items in his case. And based on that, went to Maslin. Everything up to the point of going to Maslin, as I understand it, is within the range of his admissible testimony.
Is it in his report?
Yes, all of those matches are in his report. All of those,
The report that was turned over to the defense?
correct.
All right. Mr. Blazer? I'm sorry, Mr. Bailey, who's going to address this?
Maybe it's a second.
Sure.
Mr. Bailey saying, put me in, coach, and then they're going to ignore
The
him.
reports that I read prior to yesterday's revelation had nothing to do with randomness, rareness, or anything else. They simply said it was similar, as you have correctly figured out. Second, we have a real problem here. Mr. Diedrich has a virus called Match, and he's infected Miss Clark, and that word keeps cropping up. And I don't know how you're going to enforce it, unless you get a little bit tough. I ask that you do that.
Let me respond to that, though, Your Honor. I have spoken with the witness about the word match, and we're not going to do that anymore. We're just not. And I apologize to the court. We'll have a longer discussion about it. What we will do is I propose to ask the witness a series of questions so we can both practice using the words same microscopic characteristics and other terminology that the court will find acceptable. With respect to the unusual features of the carpet fiber, this is no different than the hair comparisons. This all goes to the same general body of information that all hair and fiber examiners have, which is in order to compare hairs, they have to have unusual or distinctive characteristics, or else you can't compare them. They're
I
not
understand
suitable.
that. I understand that.
Okay, and that's the same thing with fibers.
I
If there's-
understand it.
Okay, so we don't have
But
any...
to say I compared the questioned fibers amongst themselves with the known fiber from the Bronco that we have, that's one comparison.
Right.
But then comparing it to other things, that's something different, which we
You-
don't have involved here.
You mean other years of Broncos? Is that what you're talking? No, we won't do that. Okay. All right, I understand. Thank you.
I may be heard on a discovery request.
Yes.
I'm extremely concerned about where this is all going. When I had my conversation with Mr. Diedrich yesterday about the carpet fiber, and he didn't show me his report, it wasn't provided until you ordered it, I asked him whether he had done any similar research about blue-back cotton fibers, and he said, well, he just does that kind of as a general, for all of his cases, in a general way. And so I asked him if he could give me copies of what he had, what he could accumulate. He said, it'll cost you $85. I said, I've got $85. I want that material because I think he's done other research. I think there's a large amount of other material that we have not gotten that they intend to try and get into.
My recollection of that conversation, as if you recollect, you all were using my photocopy machine to make copies of this stuff. I took that as a jocular comment by Mr. Diedrich that he ought to charge $85 for the services of photocopying.
Well, if he,
That's the way I
if he's-
understood it.
This happened before you came out and ordered the material. This had nothing to do with
All
that.
right, is there any other similar report regarding
Sit down.
blue-black cotton fiber?
Sit down.
Okay.
It's the only research I did on this case.
All right, thank you. Okay, anything else
Sanctions.
with regards to carpets and fibers? And hairs?
Before you hear from Mr. Ullman and Mr. Goldberg, there is the issue of the defense witness list. Now, we are probably a day from finishing with Mr. Diedrich, or a day and a half in terms of testimony.
You think so?
Yeah, I think so. I think you've suggested the appropriate cross-examination in this case, and I'm sure they'll take your advice.
You know, we ought to go to the Talmudic courts where the judge does all the questioning.
Talmudic courts?
And it could take 6 months.
Not in this court. All right, go ahead.
At any event, I think we have a right at this point to know what the witness lineup is going to be for the defense.
I think they agreed, Your Honor, that, and we talked about this, they'll get a list. And first of all, I think they're being optimistic with regard to when they're going to finish. Ms. Clark has previously indicated she would take a minimum of 2 days for direct. That's what she told us herself. There'll be cross-examination. And what we agreed was that as soon as they finish their case, we'll give them the list. And I think you agreed that was appropriate. We'll give them a list, and we'll give them more time than what they've given us. We're not going to just hold back and give a witness at a time. I want to give them enough so they can keep busy, because we're going to move this case along, Your Honor.
All right, my only concern, though, is Mr. Cochran, is you know what the prosecution case is. We're going to finish with Mr. Diedrich. My guess is Wednesday or Thursday.
Right?
And the next witness for the prosecution will be Juditha Brown, which my guess will be a 20-minute witness.
Should be.
And that'll be a wrap. Then we will have to go into perhaps a day of the people moving their various evidence into evidence. And I anticipate, however, I only anticipate between 12 and 20 objections to pieces of evidence, because I think everything else was pretty much agreed to previously. So we should be able to do that in half a day. And then we will get to the defense case probably Thursday afternoon or Friday. So,
We previously indicated we'll be ready to give them a list as soon as they rest. Your Honor, the problem has been with this prosecution team is that as soon as if they see something on our list, they very well may not rest, and that was the issue you were prepared
no, they've
for.
told me that they told me they're going to rest after Mrs. Brown.
That was the representation, and we think that that'll be the case. Of course, there are probably a few stipulations we may need to enter into in terms of some of the exhibits, but I don't think there'll be any need to call any additional witnesses beyond what we've indicated already. At any event, the rule of the deal has been 3 days, and,
Right.
like that
I agree
rule
with you
being
that by
enforced.
tomorrow we may hit the 3 days.
Well, unfortunately, I won't be here tomorrow, as the court is aware. May I give the list on Wednesday morning on our return? And I'll make sure they have it Wednesday morning. Your Honor, there's going to be, by the time they finish this case, trust me, it'll be probably more like Friday before we can start, but they'll have enough time, Your Honor.
Wednesday morning.
Wednesday morning? Thank you, Your
morning.
Honor.
Perfect timing, Marty.
By the way, someone will be here.
Oh, I'm sorry, Wednesday
Are we starting
morning.
Wednesday at what time?
Yes, I know.
We're gonna start a little-
Mr. Darden, we're not going to finish Mr. Diedrich tomorrow.
We're going to start a little bit, I don't think so.
And if you recollect, we agreed on Wednesday we would start at 10:30.
So Wednesday, 10:30. Thank you.
All right, and so that gets us to Thursday and Friday.
May I inquire, Ms. Clark, I don't know whether there's any possibility she'll finish in the morning.
I'd like to say yes, but I really doubt it.
Mr. Bailey, there are just too many of these hairs, and
I understand. I simply wanted understanding that if she does finish, I'd like the weekend to go through all these exhibits, which we just saw yesterday with my expert in detail, before having to start. Thank you.
okay, let's move on to the motion. There is a motion to strike, actually, a renewed motion to strike with regards to the foundation for the blood evidence, which I think is the appropriate characterization of where we are at this point.
I believe that's an accurate characterization, Your Honor. Actually, this motion really renews prior objection to the admission of comparative evidence using the reference sample of Mr. Simpson's blood sample prior to the appropriate laying of a foundation for the admission of that blood sample. And I believe Your Honor's ruling at the time was that you were not going to dictate to the prosecution the order of their proof, that we could proceed subject to the laying of a foundation. Our motion at this point calls to the court's attention that there is no foundation in this record for the admission of a reference sample of Mr. Simpson's blood. And therefore, unless the prosecution is going to offer some additional evidence to lay that foundation, all of the DNA comparisons and all of the conventional serology comparisons comparing the reference sample of the alleged reference sample of Mr. Simpson's blood must be excluded from evidence. Now, the prosecution has filed with the court a trial brief number 7, in which they assert that there is no need to call
the nurse who actually drew the blood from Mr. Simpson in order
Excuse me,
to...
Mr. Allman, forgive me for interrupting you. Do we have People's 183 available? All right, may I have that, please?
I believe what we have available is a photo of People's 183. The actual exhibit itself has never been produced or offered in evidence other than a photograph. Certainly, calling the nurse would be the most obvious and direct way to lay this foundation, and there is at this point no explanation for the failure to call the nurse. The closest thing to an explanation comes in an argument contained in this brief that somehow the defense should be precluded from inquiring of the nurse as to how much blood was drawn at the time of the actual taking of the sample. But the problem, of course, is that what is represented in this brief misrepresents the testimony of the nurse. It's asserted here that the defense will never be able to establish a sufficient foundation for Nurse Paratus to testify to the amount of blood drawn from the defendant. The reason is that Nurse Paratus will testify that he has virtually no experience measuring the amount of blood drawn from a person and put in a reference vial. Moreover, he did not measure the amount of blood drawn in this case. His prior testimony as to the amount of blood drawn was a complete guess, lacking any foundation whatever. And that is simply not an accurate characterization of Nurse Paratus's testimony at the preliminary hearing. The testimony at the preliminary hearing proceeded as follows.
Counsel, can you give me the page on that?
Yes, this is page 25 of the preliminary proceedings on Thursday, July 7th, 1994.
Thank you.
Cross-examination by Mr. Shapiro. Question: how much blood did you withdraw from Mr. Simpson? Answer: approximately 8 cc's. Question: when you say approximately, you did not measure the amount? Answer: well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe, and it looked at about 8 cc's. I withdrew the needle from his arm. Question: nobody asked you to take a precise amount of blood? Answer: no. Question: and you did not record the amount of blood you took? Answer: no. It's just routinely, that's about the amount I usually draw. Question: and you do this on a routine basis every day? You do this every day in the jail, take blood? Answer: whenever, not for this sort of thing, it's usually for alcohol, blood alcohol. Question: but you do take blood on a regular basis? Answer: yes. So it's quite clear from the prior testimony that the nurse looked at the syringe and gave a very precise range, that what he drew was from 7.9 to 8.1 cc's. We believe that the testimony of this nurse is essential to lay the foundation necessary for the people to prove, as they must, that the reference sample to which they are comparing all of the unknown blood exemplars for DNA analysis and conventional serology analysis is actually the blood of Mr. Simpson. That is not established in the record at this trial thus far by the testimony of Detective Van Adder. Detective Van Adder simply testified that he was present when the nurse drew the blood, and then he was later given a vial, a purple-topped vial, which he put into an envelope and transported back to the Rockingham scene. And there is an essential gap in that testimony. Detective Van Adder did not testify that he observed the transfer of the blood from the syringe into the purple-topped vial. Nor can we simply infer that what he was given was the same blood that was drawn in the syringe, or fill that gap simply by speculation, because any inference to that effect is rebutted by the affidavit itself that the nurse allegedly filled out at the time this transfer took place. Now, Your Honor will observe the language of that affidavit certifies that, and I'll read it, I, Thano Paratus, collected a blood sample from the right arm of the above-named subject on June 13th, 1994 at 14:30 by venipuncture using a sterile dry hypodermic needle on a needle or syringe, and using the disinfectant is identified.
Aqueous citron, I think.
Right. I deposited the sample into an evacuated clean, dry vial, which vial I received from Van Adder, and after initialing a label on the vial, I returned the vial containing the blood sample to the above officer. I declare, under penalty of perjury, that the foregoing is true, and that this declaration was executed on May 19th, 1994. Now, there's a real problem here, of course, because the date that appears on that affidavit under the evidence code must be presumed to be a true date. That is, the court, in the absence of any absence to the contrary, must presume under evidence code section 640 that a writing is truly dated. That means that on this state of the record, that affidavit was completed on May 19th, nearly a month before the alleged operation that he was describing and verifying allegedly took place. If we follow the evidence code, the certificate is on its face presumed to be a fraudulent certificate. And in the face of the existence of that fraudulent certificate, we certainly cannot infer that all of the proper procedures were followed in this case. Obviously, there were some mistakes made, and those mistakes have to be explained before Your Honor can simply infer that the proper procedure was followed and that what we have in this case is actually the blood that was drawn by that syringe from Mr. Simpson. So we don't have a foundation in the testimony of Detective Van Adder, nor do we have a foundation in this affidavit or certificate itself. The people have made the argument in their trial brief that the California Evidence Code permits the court to utilize this certificate as a business record, so that through hearsay contained in the certificate, we can lay the foundation. There are two problems with that, actually three problems. The first problem, of course, is that the certificate is presumptively fraudulent. The second problem is that no foundation was ever laid to establish that this certificate is, in fact, a business record. No person in the course of this trial has gotten on the witness stand and testified that this certificate was made in the regular course of business, that it was made at or near the time of the act or condition or event, that the custodian or other qualified witness testifies to its identity and the mode of its preparation, and the sources of information and method and time of preparation were such as to indicate its trustworthiness. Those are foundational requirements required for any exhibit to be admitted as a business record. We don't have any testimony to establish that. All we have is a photograph produced through another witness who was not even present when this certificate was made, saying that when the blood was brought to the laboratory, this certificate accompanied it. And that does not supply the necessary foundation to establish that this certificate is indeed a business record or an official record. The third problem with this is that there is no legal authority in California to allow the identity of the donor of a sample to be tested in a laboratory to be established by hearsay evidence through the use of a business record or an official record. The only legal authority presented by the prosecution is the case of County of Sonoma versus Grant W. And if Your Honor will look at that case, you will discover that the identity of the donor was stipulated in that case. So the purpose of offering a hearsay record in that case was not to prove where the substance had come from. It was simply to prove the routine laboratory analysis of the substance. And that's very different from relying on a hearsay record to establish the identity of who the actual donor of the substance examined was. There are problems with the use of hearsay for this purpose. Number one, it deprives the defendant of the opportunity and right to cross-examine. And the answer to that is going to be, well, if you want to cross-examine, you can...
I know. Hi, Jesse. No, this is so redundant. We need a better word than redundant to describe what I'm about to say is, but what a fantastic waste of time. All of these words, every single word that this man has said for the last, how long has he been up there? Like 18 hours? How long has this stream been going on? 20 hours? Waste of time.
can call him yourself. The evidence code gives us the right under Section 1203 to call to the witness stand
been
and
30 minutes.
cross-examine the declarant of any hearsay statement. So certainly, we have that right. But exercising that right, obviously, is going to come at a price. And the price that will be exacted in this case is that if we have to call the nurse ourselves to cross-examine him, we are put in the position of then bolstering the prosecution's case and supplying an essential element necessary to the proof of their case. And that is precisely the situation that was addressed by the United States Court of Appeals for the Ninth Circuit.
Sounds good to
In
me.
the case that I supplied to Your Honor that was just decided last March. The case is Wigglesworth versus Oregon. And in that case, the court was confronted with an Oregon statute that permits a laboratory report with respect to the identity of a drug to be admitted without testimony by the technician who conducted the analysis, but gives the defendant then the right to call and cross-examine the technician. And the court noted that the dilemma this presents to the defendant to either forego cross-examination or risk bolstering the prosecution's case had been avoided in Oregon by an Oregon Supreme Court opinion that is also with the material supplied to the court, State versus Hancock, to say that in such a situation, then the cross-examination must occur during the state's case in chief. That is, the defendant must be given the opportunity to cross-examine during the state's case in chief before the hearsay report is admitted in evidence to supply the essential element. But since the Wigglesworth case had come before the trial court, before the Hancock decision had come down, and the defendant had not been given that opportunity, the court found that there was a violation of due process and granted a writ of habeas corpus. So I want to make it very clear that the objection of the defendant to supplying this essential element of the prosecution's case through hearsay is not only an objection based on grounds of the denial of the constitutional right of confrontation, but also a denial of due process in the sense of requiring the defendant, if he wishes to assert his opportunity to cross-examine, to himself risk supplying that missing element of the prosecution case. So to sum up, on the state of the record we have right now, at this point in the trial, and the people have indicated they do not intend to call Nurse Paratus, we are missing an essential gap with respect to the chain of custody of the blood that was drawn from Mr. Simpson's arm in terms of that actually being the blood that provided the reference samples. That gap cannot be filled by the testimony of Detective Van Adder, and in any event, it is rebutted by the existence of a certificate which is presumptively fraudulent, in which the nurse is certifying that the procedure under which this blood was drawn and placed in a vial, certified on May 19th, 1994, a month before the procedure actually took place. So that discrepancy has to be explained before we can find the necessary foundation, and the only way to explain it is to call Nurse Paratus to the witness stand.
Thank you. Mr. Goldberg.
Good afternoon, Your Honor.
Good afternoon, Mr. Goldberg.
Your Honor, before I begin, I'd like to give the court a copy of some excerpts from the transcript that I typed up that I'd like to refer to, and it might be easier if the court had it.
I have them in front of me. I believe I have all the relevant.
You may or may not, and
right,
I
well,
highlighted
sure.
certain things.
Sure.
I gave a copy to the defense counsel.
All right.
Your Honor, I'd also inquire whether the court's copy of People's 183 for identification depicts the May 19th date, because on my photograph it was covered over by a piece of red tape.
It is covered over by a piece of red tape. However, the tape is semi-transparent, and it does appear to be a 5 to me, and I did look at it with a magnifying glass this afternoon.
Okay, because on my copy, as I said, I could not see that, although I don't think that's particularly important at any rate. I'd like to address counsel's argument and why it is that we have proven the chain of custody of the blood vial, and I'd like to divide it up into 3 points. First, I'd like to clarify what I regard to be, and what I also believe the defense has defined as the rather narrow issue that the court has to decide this afternoon. In other words, focus the court's attention on what really is the only issue before the court. Then I'd like to discuss the sufficiency of Detective Van Adder and Detective Lang's testimony in establishing the chain of custody. And then thirdly, I'd like to discuss the business records or official records exception to the hearsay rule. But the court need never reach that third issue because I think you can dispose this on the first and second issues. First, the people in the defense appear to agree, if you read the moving papers, that the law of the state of California is, with respect to a blood vial, a reference file, that the chain of custody of that reference file can be established by a police officer who says that they were present and saw it being drawn and then took custody of that reference file. The case that we cited for that proposition was People versus Lewis, and counsel also cited it. We both agree on how to interpret it. That's exactly what happened there, and I think we don't really need a case to tell us that because we know that routinely that is how it is done in courts and probably in front of Your Honor, even in driving under the influence cases where the officer says, I was present, the blood sample was drawn, I took custody of it, and delivered it to the crime laboratory, and that is all that is needed in order to establish that the item is what it purports to be. Where we appear to disagree is we appear to disagree as to the sufficiency of Detective Lang and Van Adder's testimony in accomplishing that end. And to be even more precise in framing the issue, what the defense has said in their moving papers is they have said that the alleged gap in the chain of custody exists at a single link of the chain, so to speak, in the jail dispensary. They say that between the time that the blood left the defendant's arm and ended up in the possession of Detective Van Adder, there is a gap that prevents us from establishing chain of custody, according to cases such as People versus Lewis and ordinary principles of common sense. So it is that precise link in the chain, the point in time between the time that the blood left the defendant's arm, which Detective Van Adder saw and Detective Lang saw, and the time that they took physical possession of it, that the defense claims this gap exists where the prosecution has failed to prove chain of custody. That is the only issue before this court, and the only issue that the court is now being asked to decide and has to decide this afternoon. The other issues the court need never reach at all if it resolves that issue, as I'm confident the court will, in favor of the prosecution. Now, to take a look at the case law briefly before I get into the transcript, just to drive home the point that this really is the only issue. Not only do the people in the defense agree in our interpretation of People versus Lewis, but I think we also agree in our interpretation of the other cases cited by the defense, most notably American Mutual, which was a civil case in which the decedent died in a car accident and his heirs wanted to obtain money from an insurance company, and there was a defense that he was intoxicated. It was back in the days of contributory negligence.
You're killing me.
And the defense in that case wanted to show that he was intoxicated at the time. In that case, there was absolutely no evidence whatsoever, not a business
Prosecution
record,
has
not an
one
official
more
record,
witness.
no precipient witness
One
who
more.
saw the blood vial being drawn from the defendant. But there was a blood vial that was introduced that purported to be his blood. And all the court said there, quote, on page 497, it is rudimentary that a specimen taken from a human body for the purposes of analysis must be identified before such specimen or any analysis made from it attains standing as evidence, unquote. Well, we don't need a case to tell us that. We know that from common sense. There has to be some evidence to say this blood came from this individual. That is all this case is saying, American Mutual. The other two cases, and I won't discuss them in any more detail, that counsel cited are McGowan and Madden, which both cited American Mutual, quoted the exact language that I just quoted to the court. Actually, it wasn't a quote, but they used the exact same language, stood for the exact same proposition, and in those three cases, there was zero evidence, not any evidence whatsoever, not a precipient witness, not an admissible business or official record, as to where this blood came from. And the court simply said, well, you have to have some evidence to show that it is what it purports to be. We have that evidence here, and the evidence is rather clear. Looking at the transcript testimony, Your Honor, and I wrote out what I regard to be some of the more relevant points. Under number 1 on my summary, we have testimony that Detective Van Adder and the defendant went to the jail dispensary, establishing personal knowledge. This is the part that counsel claims is lacking. We have Detective Van Adder asking the nurse to draw a blood sample for him, again, establishing personal knowledge. We have him testifying, according to both the people and the defense, that he personally observed the blood sample being drawn from the defendant with a syringe, again, establishing personal knowledge. And to quote under number 4 on my summary, what did you do with the blood sample, if anything, after it was taken? Answer, I maintained custody of the blood sample and turned it over to the criminalist. It seems pretty unambiguous. He's
same.
standing there, he's watching
to
this happen, he
focus
sees it
and
taken,
can't.
and the blood sample is then turned over to him, and he brings it to Mr. Fung. Next, under where I'm summarizing Van Adder's testimony on cross, and this is
Here's
perhaps
what
even
I
more
think,
significant.
and I
Mr.
don't
Shapiro
know.
asked question.
Are they questioning whether that is OJ's blood because the date was wrong on a certificate? Is that? I don't even. They. I think I could be wrong. Maybe they're just talking.
Where was Detective Lang at the time you took OJ's blood sample from the nurse? Answer, he was with me. There's never been any doubt in this case as to whose blood sample that is, and that Detective Van Adder had personal knowledge
I was
of it.
wrong.
It is almost
That's
as if
not
the
the
defense
problem.
now wants to somehow strike the question that was asked by Mr. Shapiro and the answer given as lacking foundation for personal knowledge. It was clear to Mr. Shapiro, as it was to everyone listening to this testimony, that these are events that he observed and witnessed that he has personal knowledge of. I won't read some of the remainder of the testimony that I've summarized over there, but I'd like to skip over to Detective Lang's testimony on direct examination, where he was asked question, were you present when the blood sample was taken from the defendant? Answer, yes. Question, and where did it go after that? Answer, it went into my partner's possession. And then later, okay, did you see it after the blood sample was drawn from the defendant and given to Detective Van Adder? Yes. When did you see it? At the time it was withdrawn and turned over. It's very clear that they are there, that they are witnessing this, that he sees the blood drawn and he sees it turned over to Detective Van Adder. Now, what counsel is saying is that there's some sort of a gap. I don't see the gap. But what would this gap be? What happened? Did Detective Van Adder and Detective Lang suddenly become very squeamish, these two seasoned homicide detectives, and they fainted upon seeing the blood drawn from the defendant's arm? Nurse Paratus woke them up by slapping them after he had switched the blood vials and handed the blood vial to Detective Van Adder. So Detective Van Adder really doesn't know from his own personal
love
knowledge
food.
that the vial came from the defendant's arm. Or
And the rest
did
of
he
it,
ask
but I
Detective
love
Van Adder
food
and Lang,
and
will you gentlemen
beer
please turn your back
and
to
them
us,
together.
close your eyes, and count to 10 for a few moments, and then he switched the blood vials.
You're
and
not
handed
going to
it them.
object to this, guys?
Or did he ask them to leave the room? I mean, we can't really think of a logical scenario under which they didn't have personal knowledge of these events. It's very clear that they were there, that these are things that they saw and witnessed, and that they're testifying to a continuous sequence of events. And if that did happen, when he asked Detective Lang, where did the vial go after the blood was drawn, Detective Lang would say, I don't know, because I was on the floor, I just fainted. So this argument is clearly without merit, and the transcript testimony is absolutely 100% clear. But if there is an alleged ambiguity, Your Honor, then isn't that
I
something that, of
love
course, the jury
dancing.
ultimately has to decide? Because ultimately it is a jury issue. And let me just say on that score, this is not something that we're concerned about. Because if there really was this ambiguity that counsel is talking about, we'd want to do something to clarify, because we wouldn't want the case to go to the jury in a posture where a legitimate argument could be made by Mr. Cochran that we really don't know whether the reference sample came from the defendant or some other person that might have been present at the dispensary at that time who really committed this crime coincidentally. But Mr. Cochran is not going to make that argument. And if he does, of course, we'll be very happy. But he's not going to make that argument, not only because it can't be supported by the transcript, and it's not logical and doesn't involve common sense, not only because we all know that this is the defendant's blood. There are many issues the defense has raised in this case. They've talked about contamination, conspiracy, and whether things have been switched. But Mr. Cochran is not really going to stand before the jury and say, we really don't know if this reference sample came from the defendant or not, because it's not plausible. And because he really can't argue that. Because there's another way that we can prove chain of custody, or the identity of whose blood the reference sample is, that is given to us by the advent of DNA technology that wasn't available at the time that many of the cases that I've cited to the court and that counsel cited were written. And that is that we know that item number 12 and item number 14, concededly, both parties agree to this, are blood from the defendant. I'm talking about the dots of blood in the foyer, 12, and 14, the dot of blood in the bathroom. And remember, all we have to do here is to prove that the blood is what it purports to be, in other words, blood from the arm of the defendant. We know that those are the defendant's samples, not only because both parties seem to agree to that, but also because, as to item number 12, if I'm not mistaken, I'm sure the court will correct me if I am, we have a 5-probe match on DNA, DQ alpha, and also polymarkers. And although the court may not like the word match, that seems like a match. That seems like virtual identity, and I don't think Mr. Cochran's really going to argue to the contrary. And we know that that matches the reference file. So we know circumstantially, even without Thonoprotis, even without Detective Van Adder or Lang, from the DNA evidence, that what is concededly blood of the defendant in his home matches the reference file, so the reference file really didn't come from the mystery person that was present in the dispensary and whose blood was substituted while Detective Van Adder and Lang were out cold on the floor. So if there is any alleged ambiguity, and we don't think there is, it's clearly a jury issue, and it's a jury issue that the people are not at all concerned about, and I don't think that Mr. Cochran is going to do a lot of arguing about when he has his opportunity to address the jury. Legally, he can. Tactically, he won't.
Oh, he is going to do a lot
I'd now
of
like to discuss
arguing.
the business
Let
records
me
exception,
tell
Your
you.
Honor, and the official records exception,
A
although, as
lot
I
of
said to the
arguing.
court in trying to define the issues, the court does not have to address that issue at all. It's completely unnecessary, because as soon as the court concludes, yes, this is sufficient, this is enough evidence to go before a jury, you don't have to reach this. And what I would say is that chain of custody, of course, is a factual issue, not really a legal one. It simply involves common sense, trying to prove that something is what the proponent is saying it is. And the only difference between the decision that Your Honor is being asked to make this afternoon and the decision that the jury will be asked to make is that the standard of proof is different. Otherwise, everything else is the same. It's a common sense
That
issue.
one
It's a
guy
factual
bought
issue.
it.
The standard of proof for the jury could be beyond a
popping
reasonable
tags
doubt
and made
in
a
their
song
estimation.
about
If they
it.
find that this evidence is one of the circumstances that goes into a chain of circumstances upon which the people are relying to prove the guilt of the defendant, they would have to find beyond a reasonable doubt that the item is what we say it is, in other words, the defendant's blood, according to the circumstantial evidence instruction. But the standard of proof for Your Honor is merely whether there's enough evidence, in other words, a prima facie case, in order to be able to submit this factual dispute, if we can call it that, to the jury. And clearly, if the argument that it's not the defendant's blood is so poor that I don't think the defense will ever make it in front of the jury, I don't see why the court would accept it here, where the standard of proof that Your Honor is going to apply is significantly lower than the standard of proof that they will apply. But to get to the business records exception, I don't want to belabor the issue. I'll try to address it quickly, because as I said, I don't think the court needs to necessarily reach this. There are just a couple of points I would like to make. First of all, what we are relying on to be more accurate in my terminology is not the business records exception, but the official records exception. And the only distinction between those two exceptions is that the official records exception does not require a custodian or other qualified witness to testify in order for the record to come in. Official records can be and usually are self-authenticating. And in the article that I appended to my points and authorities, I described how it is that a laboratory report, and we're not dealing with a laboratory report here, that's even a more complex issue, but how a laboratory report can come into court without ever having any witness testify in order to lay any foundation for that record under the official records exception. And Jefferson also talks about this in his treatise. And I won't go into all the elements of how that can be done. I laid it out. It was fairly succinct. It was on page 19 of the article that I read. And there are various inferences and presumptions that you apply in allowing an official record in without having an authenticating witness. The only one that I would like to specifically discuss, since the court, if the court feels it needs to, could simply look at that portion of my article. The only portion I would like to specifically discuss is the timeliness requirement, because it has been raised by counsel. That is the suggestion that here the evidence envelope contains the date of May the 19th. And what I would say there is that the case of People versus Utter, which we discussed and I also discussed in my article, says that one of the ways we can get an official record in without having a witness testify and prove the timeliness requirement that it was made at or near the time of the act, condition, or event described therein is that we have a presumption in the state of California, as counsel noted, that a record that contains a date is deemed to have been or is presumed to be truly dated. And when the record indicates that the date that the record was filled out is the same as the date that the analysis was performed, in People versus Utter, it was a chemical analysis, a laboratory report, that the timeliness requirement is satisfied simply by looking at the date on the evidence itself. In other words, if you have a date on an analyzed evidence report saying, I did this analysis on June the 13th, and the report is dated June the 13th, and you have evidence indicating that the test was on June the 13th, that in and of itself establishes the timeliness requirement without anyone testifying that it was made at or near the time of the act, condition, or event. Of course, here we can establish it because we know that the defendant was brought in on June the 13th at the time that's contained on this record, and we also know from Detective Van Adder that he received this envelope and that it obviously was filled out before he received it. So we can infer and presume the timeliness requirement from the face of the record itself. And the record is dated June the 13th as to the date that the blood was drawn. The May the 19th date is entirely irrelevant from a legal perspective, because if the court reads this, what I call the chain of custody statement, it is in the form of a declaration, the declaration saying, I declare under penalty of perjury that the foregoing is true, and that this declaration was executed on 5/19/94. So the declaration is invalid. because it obviously couldn't have been executed on 5/1994. Presumably, Mr. Paradas filled out the declaration portion of this prior to the time that he actually drew the blood. But the declaration portion was never admissible because we do not allow in declarations as any exception to the hearsay rule except in motions. But before a jury, the declaration itself isn't admissible. What makes this admissible is not that it's in the form of a declaration and executed under penalty of perjury. What makes it admissible is that it meets all the requirements of the official records exception to the hearsay rule. So if there was no declaration on it, if it didn't say this is under penalty of perjury, it would be equally admissible. And the fact that there is a declaration under penalty of perjury doesn't make it any more admissible. The fact that it's incorrectly dated doesn't make it any less admissible. It's simply irrelevant from a legal perspective. Moreover, this document has been published before the jury without objection, most notably in the testimony of Colin Yamauchi summarized under number 5 on my points and authorities, where Mr. Yamauchi is asked on cross-examination by the defense attorney question. Now, let's move in on the bottom half from, quote, officers requesting withdrawal, unquote, down. Now, do you recognize this to be a picture of the envelope that contained Mr. Simpson's blood vial? Again, everyone understands that the testimony has established this is Mr. Simpson's blood vial. And obviously, they can't now object to their own question. We didn't object. Answer. It's kind of hard to read, but I recognize the name of the nurse that corresponds to the vial of blood and my notes. Question. And can you see now that this box we're focusing in on now refers to the affidavit of the person withdrawing blood? Answer. I can read that affidavit. Quote, a person withdrawing blood, unquote. Question. And it indicates that Thano Paradas, the nurse, gave the blood vial to Detective Van Adder. So here we have the defense again publishing this, and it had previously been published by the people, in front of the jury, reading the declaration, putting it up on the Elmo, and now they're saying that we're supposed to essentially unring that bell or strike that testimony, even though they elicited it, and unpublish this document. And on that score, I'd just like to bring to the court's attention the case of People versus Dorsey, which talks about the necessity of making specific and timely objections, and may also be of interest to the court later on in other issues that I'm sure the court is going to confront when it comes time to moving in exhibits.
All right, Mr. Colbert, would you conclude your remarks?
This is the conclusion.
You're at 20 minutes now.
This is the conclusion. And I may just point out, Your Honor, that we did file
Judge,
a
you
brief
said
versus
hours
technically
wrong.
moving party. So that would entitle us to 2 arguments.
Yes and
But-
no, because it's actually, the genesis of this was a motion to strike.
Okay. Well, at any rate, I was concluding, Your Honor.
All right.
And maybe I shouldn't have taken so long, because this really is an extremely simple issue and should be resolved simply by looking at Detective Van Adder's testimony, and I do apologize for that. And I hope I haven't made it
I'm gonna
sound more
slap him.
complex than it really is.
Shut
by
up.
Treating it perhaps with more seriousness than it
Drag it
actually
out.
deserves.
Just drag
But
it
at any
out.
rate, in Dorsey, what happens was that a bank record was introduced in a non-sufficient funds case under the business records exception, but there was no testimony at all that it was prepared at or near the time of the act conditioner event, and no testimony as to the mode of preparation. And counsel in that case for the defense objected, objection no foundation, repeatedly, and the objections were overruled. What the court held in Dorsey is that that objection was not sufficiently specific, because when you're making an objection, you have to state the specific grounds, which would mean that the specific objection that should have been made at that time is objection no foundation as to manner and mode of preparation.
Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Douglas, Mr. Bailey, Mr. Blazer. People.
I think, okay, either the cameraman just gave up or the cameraman ran out of tape. Either way is great. Thank you, cameraman, unseen hero of the day.
Represented by Ms. Clark, Mr. Darden, and Mr. Escobar. Ms. Clark.
Yes, ma'am. Good morning. I'm asking leave of the court to be heard concerning the terminology of the use of the word match by our expert,
Oh,
Mr.
please,
Diedrich. And
please
the reason I'm
don't,
asking leave
please,
of the court to be heard on this is that
please.
we have citations for the court in which such language was used by the expert testifying. And we also have reference to the very guide Mr. Bailey was referring to yesterday, which indicates that the use of the term match is appropriate under these circumstances. We also have page 7. We also have citations coming in by fax from around the country in which other experts have used the terminology match in the
Isn't
arena.
this a little late?
Well, I never anticipated the court would preclude the use of the word until the ruling yesterday. And I did not have, obviously, during the time I was presenting testimony, I didn't have time to do the research. I did last night. But it had been my anticipation that the
Bobby.
court was going to rule in favor of the defense motion in that regard. I would have done the research in advance, but I did not have any advance warning of that.
So what would you like me to do?
I'm going to cite to the court the cases, and I would like the court to permit the expert to use the terminology because it is very cumbersome for him to continually be thinking up terms that he would not use in place of the term he is accustomed to using and has been approved in all of the courts he's testified to, thus 400 times prior to this. The Hicks Guide,
Book?
Microscopy of Hair, which was brought out by Mr. Bailey at sidebar yesterday, states the following. Hairs found on the rape victim's clothing, which match the suspect's hair, serve to corroborate her statements when the suspect denies any contact, indicating obviously the approval of the use of the terminology match. In People v. Bonin, 47 Cal 3rd 808, at page 823, it indicates that the prosecution presented expert testimony to the following effect. Among other things, the bodies of Gatlin, Grabs, and Maccabee each revealed the presence of foreign hair that matched defendants. People v. Thomas, 180 Cal App 3rd, page 47 at page 51. That expert testimony is being was proffered, and it indicates pubic hair identical to defendants was found in Priscilla's bed. Similarly, pubic hair matching that of Priscilla's was found in a combing of defendant's pubic hair at the time of his arrest.
All right, do you have any cases specifically on point, counsel, regarding terminology?
We have cases coming in by fax as we speak, Your Honor. But the use of the summary of the terminology given in the factual synopses of these cases in the course of the court's own language, which is the court's synopsis of the expert testimony, indicates that that terminology was used appropriately.
No. Do you have any cases specifically on the point of the terminology?
I'm going to find out now, because the faxes are coming in. We asked for them last night, and they're coming in this morning. There was a time delay, 3-hour time delay. But I think that the mere fact that we have it used in the guide that Mr. Bailey himself proffered to the court as the Bible on this subject should lay to rest any issues we have with respect to the propriety of that terminology. And I apologize to the court for not having brought it to the court's attention sooner, but there was no way that I could know that this issue was going to be raised by Mr. Bailey or that there was going to be a ruling that there was. It was raised just yesterday.
No, counsel, this is an issue that we discussed informally over the last month, and it's been raised several times.
The issue of the word match in hair?
Absolutely.
Hair and fiber?
Absolutely. This is not a new issue. If you go back and find,
apologize to the
you go
court.
back and find it in the record, I'm certain it's there in the sidebar conversations at least a dozen times.
Then I apologize to the court.
All right, do you have any other comment?
Yes, I'd like the opportunity to present the court with the additional cases that are coming in through fax right now. I apologize to the court then if I was remiss in not having brought these cases to the court sooner. I don't recall having had the issue raised, and I defer to the court's recollection of that. And I would ask that the expert be allowed to use the term
All right, specifically, what terminology are you citing to the court on page 823?
of
Bonin?
Bonin. At the bottom of the page, Your Honor, the last paragraph where it says the prosecution presented expert testimony to the following effect.
Mm-hmm.
I wish we knew who was muting, because they're doing a great job.
All right, any other comment?
Yes, Your Honor, I have a case in front of me now. I'll first cite to the court from the FBI Forensic Science Research and Training Center, a report prepared in 1982.
She's
The
scrambling.
relevant language is on the
It's not
last
gonna
line.
work.
It says, however, the quote-unquote duplicate hair criterion for a
Oh, I'm
match
hungry. I
should be
should
the ultimate
order
goal.
something.
I'll submit this to Deidre so the court can see it. Another highlighted passage of this symposium, let me quote, "The most important decision made by the hair examiner is deciding when a hair can be said to match or be consistent with originating from a particular individual."
Deputy McNair, would you collect Detective Lang's pager for me, please?
The following cases being sent to us right now, they are out-of-state cases, but they deal with a issue of the terminology.
Ms. Clark, let's cut to the chase here. Are
There's
you
more.
asking for 402 on the terminology match?
Yes, Your Honor. I have more here as well. From Forensic Sciences International. In essence, an investigator attempts to assess the likelihood of matching fibers. Again, matching fibers were found on only 10 garments searched. Results of a study to determine the probability of chance match occurrences between fibers known to be from different sources, a paper written by Wilken Fong and S. Henry Inami, in which the abstract begins with the following: the results of a study to determine the frequency of chance match occurrences among fibers.
All right.
And again, then, in another paper published by Richard Bisbing and Michael Wollner, natural variation does not preclude the association of hair because sometimes variation serves to personalize the hair specimen. When comparing several hairs from one source, it can sometimes be demonstrated that the questioned hair not only has the traits of the known hair, but that the variation in the questioned specimens matches the variation occurring in the exemplar.
All right. I'll hear from the defense.
Shall I?
Mr. Bailey.
On the page 7 from which Ms. Clark read, it is concluded that, based on this comparison, the examiner may conclude, number 1, that the hairs are consistent or similar and could have come from the same source, number 2, that the hairs are dissimilar and did not come from the same source, or 3, that the hairs possess characteristics which are not sufficiently defined to arrive at a meaningful conclusion. Only those 3 conclusions are permitted, according to this manual, which, although published in 1977, Mr. Diedrich himself told me on Wednesday has never been republished, updated, or changed, or modified. Every book that deals with hair and fiber comparison states it in the same terms. Now, the word match, as used in appellate decisions and used once on this page, is a dangerous word because of the connotations to a layman. When you say a perfect match, you may be talking about a male and a female who are not identical, but who fit together well. The word match normally is interpreted to mean identity. That is, the same in every respect. If this jury is given the idea by these niceties of language which have been deliberately injected, despite your order to the contrary, throughout his testimony, and used by Ms. Clark with some frequency, and the jury gets the impression that this witness is saying this is O.J. Simpson's hair,
Mr. Bailey.
even though he has testified under oath that he can never claim that he has identified a hair as belonging to any one individual, but
Okay,
has
then.
subscribed to the limitations in this FBI
If he said that he cannot, then the word match is fine. It's a word that they always use. Stop.
manual, which I presume he himself, as section chief, would have amended, updated, or rewritten if the rules had somehow changed or the technology advanced to the point where single source identification was possible. I don't believe it's fair to have him on the one hand tell the jury, I can't say that it came from this source, and on the other hand, that's a match. It's confusing, and it runs the risk that one or more jurors will interpret that as a positive identification when it is no such thing and never can be in hair and fiber technology. That's our position on it. We ask that you continue to prohibit the use of the word match simply because the dictionary definition brings it perilously close in the minds of many and in common usage to identity. And that is wrong, unfair, improper, and I believe would be an error, despite the language in appellate decisions which describe microscopic consistency as a match. That is not to say that the examiner who testified in those cases was allowed to use that word in his testimony, and if he was, I suggest that that was improper. A second matter, Your Honor, that I would like to raise before we bring the jury in. We have some concern based on a theory spun out by Ms. Clark as to how the wrapped-around hair that you pointed out when we were reviewing the boards a couple of days ago on Nicole Brown's, the wrapped-around fiber on Nicole Brown's hair that was found on Goldman's shirt, got that way. She speculated that there may have been something Mr. Simpson was doing as the alleged murderer that caused that to wrap around. I was concerned. I spoke to Mr. Diedrich. He speculates that something was rolling, and that's how it happened. And I would like some kind of voir dire on that, Your Honor, because if he has no real idea and is simply speculating, I don't think the question should be put to him. We do note that when Ms. Clark assured you he would explain how that occurred, he leaned over to Mr. Van Adder and said, I hope. I got the impression from talking with him yesterday that he has no clear idea how it happened and is simply speculating. And I would like to preclude any such speculation if it doesn't have sufficient foundation before the answer is given. And I'd like Your Honor to make some inquiry into that aspect of it, if you will.
All right. Ms. Clark, do you want to address that last issue, the wrapped hair?
One second. This just came in, Your Honor. I'm sure Mr. Diedrich can authenticate it, but from some lawyers in Anchorage, Alaska. They sent us a quote from a transcript in an Anthony case. The strongest statement we make is the hair could have originated from that person. Now, that's the same witness. He said that before you, Your Honor, a couple of times yesterday, and I don't like to see it embellished any further than it already has been. And I would like to see the limitation of the word match that you imposed yesterday enforced with some regularity. Thank you.
That's stupid.
Let me assist the court. What we have here is a fundamental lack of understanding on the part of the defense as to apples and oranges here. The finding of a match is what permits the expert to draw the conclusion that the hair could have originated from this person's head.
I mean,
The two are distinct issues. The finding of a match does not mean that they are therefore saying it came from only this individual. And every time this expert, Mr. Diedrich, testifies to the fact that he found a match, it will then be concluded by him that the hair could have originated from Mr. Simpson. He'll never say that the match indicates identity. But unless he finds a match, he cannot even say it could have come from the head of Mr. Simpson or the head of Nicole Brown or Ronald Goldman. That's the issue. And counsel is confused between the terminology that permits the conclusion ultimately to be reached that he just read to you and the finding and the observations that are made that lead to that conclusion. There are three possible conclusions a hair examiner can reach, and Mr. Diedrich is in complete conformity with the Hicks Guide that says of the three, one is that it could have come from the head of a given person. But you cannot reach that conclusion until you have first found a match. And that's why we're talking apples and oranges here. And every time the word match is used by Mr. Diedrich, it will be accompanied by what that means, which is it could have come from the head of whoever. So Mr. Bailey is confused. Those terms do not, it's two separate proceedings and two separate procedures we're talking about. First you find the match, then you draw the conclusion. They are not inconsistent, they do not conflict, and they do not mislead. And that's why in previous decisions, in previous cases, experts have so testified. With respect to how the fiber came to be wrapped around the hair, just as Dr. Lakshmanan gave an educated hypothetical as to how things could have happened based on his on reasonable medical certainty and his expertise, Mr. Diedrich is also an expert of nearly 20 years' experience who may hypothesize based on his expertise and experience and judgment that the fiber could have become wrapped around the hair in a couple of possible ways. One of which is the rolling effect when you brush against, when someone's sleeve brushes against a hair, and then the fiber wraps around the hair. Another possibility, well, I don't have to get into that. But the bottom line is that within his experience and judgment, he can hypothesize, giving the educated, a reasonable scientific certainty as to how this could have occurred in his experience. That's his job. He's an expert. That's why we ask him to testify. If he didn't have that experience and didn't know any more than you or I, then why call him? Again, I do not see any possibility of misleading this jury with the use of the term match. The problem we're having with this expert, he's being continually having to say words that he's unaccustomed to saying and phrase his findings in ways that are not the norm for him. And so, yes, he slips. He's not used to doing that. For 18 years, he has done something different. He comes to this court, and now all of a sudden he can't use the term he's been using for 18 years. And that's what's causing the problem. He means no disrespect to the court. And I've been attempting to address the issue with other phraseology, but I find, having researched the literature, that it is found to be acceptable, not only in the scientific community, but in the courts as well.
All right. Thank you. All right, counsel, the problem we have here is we have a wide range of scientific evidence that has been presented here. In Webster's third New International Dictionary, the definition of the word match is as follows: one that is exactly like another, one that forms an exact pair with another, an exact counterpart. So that terminology is too close to, that terminology overstates the power of this evidence, and the court's previous ruling will stand. All right, let's have the jurors.
They're all stupid. We're just watching stupid people work.
The record reflect that we've been rejoined by all the members of our jury panel. Mr. Diedrich, would you resume the witness stand, please? All right, good morning again, Mr. Diedrich.
Good morning.
Here, sir, you reminded you were still under oath, and Ms. Clark, you may continue with your direct examination.
Thank you, Your Honor. Good morning. Mr. Diedrich, when we left off, I was asking you about the significance of finding two fibers that, a question fiber and a known fiber that exhibited the exact same microscopic characteristics. And what is the significance of that?
Well, a fiber association is significant because of the variation that exists in the environment. That is, there are many different types of fabrics, there's many different types of fibers, both naturally occurring and man-made. Because of this wide diversity, it makes a particular fiber association significant.
Let me ask you this. If I saw two black cotton shirts on a rack, they look the same on the rack. If you were to examine the fibers from the two of them microscopically, has it ever occurred that you've seen two garments that appear the same to the naked eye, when you take fibers from them, you see differences?
Well, many things appear similar, but very few things are the same in all respects. I've done studies in the past to support that.
Did you examine fibers from the evidence in the clothing of the victims in this case?
I did.
Now, in your experience, sir, what is the mobility, what is the transience of fibers in the manner in which they transfer between objects? Is it more or less than hairs?
Well, fibers will tend to transfer at a greater rate because of their size being much smaller and lighter. They will transfer more easily than hairs.
And what, if any, significance does that mobility have to you in determining whether a fiber can be associated with a crime or with a suspect?
Well, when two people come into physical contact, there's a possibility that fibers from the clothing of those individuals may be transferred. It's called a primary transfer. Fibers that are loose on the surface that actually did not come from that garment may be transferred as well. It's called a secondary transfer. Primary from the fabric, an indirect transfer would be secondary, and they occur all the time.
Well, what's an example of a secondary transfer?
Well, a secondary transfer would be one where, for instance, I sat down in this chair and there were fibers from the suit I wore yesterday. I possibly could pick up the fibers from that suit, and it would be secondary. It didn't come directly from the fabric, but indirectly through an intermediary or another surface, fabric surface. So primary transfers or direct contact transfers occur all the time, as well as secondary transfers. And in the laboratory, we look for both types of events.
Can that also happen in the case of hairs, primary and secondary transfer?
The same thing can happen. Hairs can be transferred directly from a body area, such as a head or pubic region. They can also transfer indirectly. That is, hairs that are found on the clothing of a suspect in a case, which may belong or may have originated from that individual, may be transferred during the contact as well, and that's essentially a secondary transfer.
Is it a common occurrence for us to shed hairs onto our clothing on a daily basis?
It's very common to find one's own hairs on one's own clothes.
And then if, for example, a suspect were to shed hairs on his clothing and then have contact with the victim in the course of a violent struggle, might you find hairs from the suspect's clothing, his own hairs, transferred onto the clothing of the victim?
That's very likely to occur, yes.
Have you heard of something called the Locard exchange principle?
I've heard of it, yes.
Can you explain to us what that is?
Well, the Locard exchange principle states that when two objects come into contact, physical contact, there's going to be an exchange of materials. It was originally stated, actually derived from what Mr. Locard had worked on as a French scientist, that when people work in certain environments, they come in contact with certain types of materials, they often will pick up this material on their clothing, thus indicating perhaps the type of job that they have, or what type of vehicle that they may be riding in, or what type of clothing that they're used to wearing, or whether they smoke tobacco or tobacco products. So it was derived from his work that he did in France that dealt with transfer.
And does that principle also go to fibers as well?
Well, same thing. Any type of material, foreign material or material from a fabric, could transfer just as easily. Doing the same thing. A person may have a particular type of car. Evidence of this might be found on his clothing. A person may have a particular type of clothing attire, certain types of fabrics that he wears frequently. These fibers may be found on his clothing. So these transfers occur all the time.
Okay, let's move on to this case, Mr. Diedrich. When were you assigned to this case?
Well, the evidence first came in on August 8th, 1994.
And who brought it in?
Susan Brockbank from the Los Angeles Police Department Crime Laboratory.
And was the evidence brought straight to you?
It was, yes.
What exactly is your procedure when you receive evidence from a local agency for analysis?
Well, the evidence is the evidence is taken to what's called the Evidence Control Center. And at this location, a laboratory number is assigned to the case. They indicate in their documentation that is going to be assigned to the Hairs and Fibers unit that I'm going to be what's called the principal examiner in the case. At that point, the evidence was taken to the unit where it was inventoried or checked in.
And when the property is inventoried or checked in, is there some form that's filled out?
Well, a worksheet is prepared in all cases. In this case, it was as well. The question items of evidence are listed numerically, Q item Q1, Q2, Q3, and so forth. And besides each of these Q numbers, an indication of what it is. Q1, hair from a particular item. And besides that, the number generally that identifies it from the police department, or Los Angeles Police Department identification number. All of the items are checked in and listed on a worksheet. And from this worksheet, the initial work on the case starts.
So you renumber the items submitted with your own numbering?
Right.
Q for questioned, that means recovered from the crime scene in unknown origin?
These items may contain questioned items that may be suitable for comparison with known samples or Ks.
And all the known samples have a K something, K number.
It starts with K1, K2, K3, and in the initial case as it comes in. As subsequent submissions come into the laboratory, they're run consecutively, starting with where we left off.
So is the worksheet listing out all of your numbering done first before you begin the actual examination?
Yes, that's correct. You can work off of a notebook paper too. You don't need a worksheet to start the work, but it's just a formality. It's part of the documentation.
Okay. Now, before you begin the work of analysis and examination, is there some precaution that is taken in terms of the workspace, the work area?
Well, before you actually start on an individual item to look at it for material, whether it's hair evidence or fiber evidence, those areas are cleaned.
Okay. I mean, with respect to, in this case, the hair and fiber had already been collected from the evidence items such as clothing and hat, and
Right.
et cetera. So you were submitted paper folds, correct?
Right. All of the initial items that came in were in sealed either coin envelopes or manila envelopes, and they were inventoried from that. Some of them had to be opened just so that they could be numbered, but the actual coin envelope was not opened at that time.
And was there one item of actual evidence that you did receive with Susan Brockbank on August the 8th?
Well, I consider them all items of evidence, but in actual fabric, I received the hat, the knit hat that was recovered from the scene.
The blue knit cap?
That's correct.
Before you opened the packages that you received, did you make any effort to clean surfaces or take precautions to make sure the workspace was clean?
I'm not sure exactly what stage you're referring to. When the initial check-in, there's paper spread out on the table, and the items are inventoried, but they're all in a sealed condition at that time. As each individual item is ready for examination, the surface is prepared and clean. Clean paper is put down. The forceps or tweezers are clean. Lab coats are worn. All precautions that we feel necessary to preclude the possibility of contamination.
And is the paper changed and forceps examined for cleanliness between the examination of each item?
Each item. The forceps are examined under the stereo microscope just to be sure that there's nothing on them. Hands are clean, new paper.
And did both you and Susan Brockbank wear white lab coats during the examinations of all items?
Yes, you're right. We did supply her with a lab coat.
All right, earlier did I ask you to examine a board that we have marked as People's 436 entitled a Chain of Custody Board?
Yes, I remember looking at it.
And did you examine all of the
Zach,
items
thank you
contained
so
on that
much.
board
Thank you.
to determine whether they accurately reflected the appearance of the items you received for the examination in this case?
Yes, if I could just take one last look.
Please.
All right, Mr. Escobar, you're going to have to move that back because it's blocking out juror number 7.
Just send juror number 7 home. I mean, if he can't see anything or she can't see anything, it is a she. We remember. Why is she even there? Send her home.
All right, thank you, gentlemen. Ms. Clark, you want to have Mr. Dietrich step down and look at this?
Yeah.
The only difference that I see here on this particular board is item number 113, and it indicates that the FBI numbers Q8A, B1, B2, B3, C, they're not actually in the photographs, but they came in that envelope.
And so those are those Q8, Q8A, B1, B2, B3, C, and Q9 through 19, I'll give it to the court reporter later, and Q47 were all the numbers that you assigned to what was removed from the package depicted on this chain board for item 113.
That's correct.
And Q9 through 19, were those slides that were already prepared when they arrived at the FBI on August 8th?
They were, and I believe this one blue mailer here, plastic mailer, is Q9. But there were glass microscope slides prepared and delivered for examination.
So that's an example of what you got?
That's an example, yes.
Then is everything on that board accurate with respect to the packages that you received from LAPD?
It looked accurate, yes.
And does it accurately reflect the dates on which you received these items?
Yes, it does.
Not all items were received on August 8th, correct?
That's correct.
Some were received later?
Later.
All right. Oh, there's one more board, actually.
I'll hang around.
451. All right, this is People's 451, so I also asked, I think, that you look at this earlier to determine whether the information reflected on it concerning what was received by you at the FBI and when is correct.
This board is correct.
Thank you, sir.
Not yet, Zach. I'm this close. I'm not yet, but my numbers are so good.
So with respect to
Just waiting.
results of your examinations in this case, before we step into that, I just wanted to ask you in general, with regard to hair comparisons, what conclusions can you draw from the comparison of hairs? And what, in your opinion, is the significance of hairs that exhibit the same exact microscopic characteristics?
If hairs exhibit the same microscopic characteristics, it indicates that these hairs could have originated from that individual. If hairs are different, and they're different, significantly different, it's possible to say that this hair or hairs could not have originated from a given individual. On some occasions, similarities in characteristics and differences both exist, and no conclusion may be reached regarding that type of comparison. So essentially there are three conclusions that are reached.
In your examination of the hairs collected from the evidence in this case, sir, did you find any hairs that match those of Nicole Brown?
Move to strike.
Sustained. With the court reporter, please.
He wants sanctions for that question. Sanctions. He ain't gonna get it. Because they're all stupid. They just are stupid. What a shit show. Seriously. But we only have one more witness for the prosecution. Then it really turns into a dumpster fire.
Proceed.
Thank you, Your Honor. Great. in your examination of the hairs collected from the evidence items in this case, sir, did you find any hairs that exhibited the same microscopic characteristics as those of Nicole Brown?
I did.
And were these head hairs, sir?
They were.
Where did you find those hairs?
These hairs were found on the glove identified as originating from the Rockingham location, a glove found at the Bundy location, as well as from the knit hat that was recovered at the Bundy location. Hairs that exhibited the same characteristics as those of Nicole Brown Simpson were also found on the pants and shirt of Ronald Goldman.
Now, have you seen each of those items that you've just described? The glove recovered at Rockingham, the glove recovered at Bundy, the blue knit cap recovered at Bundy, and the pants and shirt of Ronald Goldman.
I have, yes.
And I'm going to direct your attention to the monitor. These are items previously marked in evidence, Your Honor. Okay, this is People's 55G.
Right, 55D appears to be a photo of the Rockingham glove.
And this is People's. Do you recognize this item as well, sir?
Well, it looks like a glove at a crime scene.
Okay. Does it look like one of the two gloves that you saw in this case?
One of the gloves
Well, if I
did
was
look at came
horizontal,
from
I
the
would be
Bundy crime
asleep.
scene. I believe this is that glove.
People's 45A.
All right, appears to be the Bundy glove.
This is kind of hard to see. The photograph on the screen now is People's 56. Laser, and it's a little difficult to see. Your Honor, I'm going to ask to zoom it in on the Elmo if I can. People's 56I. Do you recall you indicated earlier that on August 8th,
No, it
one
might be
item of the
open.
actual,
They
fabric
got new
itself was transported to you.
roller
with the marked
coasters.
cap. Does this appear to be that cap?
It does, yes.
You might need to cut the feed for this photo.
40 degrees out is not even a coat-worthy day. You could
And the
put on a
shirt
sweater.
belonging to Ronald Goldman, do you recall having seen those items, sir?
Yes, I do.
And do those appear to be them?
They do.
And those are the items on which you found the head hairs of Nicole Brown that appear to exhibit the same microscopic characteristics as those of Nicole Brown.
No.
Yo, I don't
Yes, there were
remember,
hairs that were found
Zach.
on these items.
I know the Barnstormers has delicious hot chocolate, like out of the park, delicious hot chocolate. I think Dutch Wonderland does too, but I could be wrong. I'm trying to remember. If you go, get some hot chocolate. Yes, get some hot chocolate.
That exhibited the same microscopic characteristics as the known hairs submitted to me from Nicole Brown Simpson.
And I have a board here, Your Honor, I'd ask you to mark People's next in order of People's
It wakes you up.
75.
475. I'm going to remove the strip concerning Nicole Brown to reveal the results just testified to by Mr. Diedrich. Did any of the hairs that you found on either of the gloves or the clothing of Mr. Goldman appear to be forcibly removed?
The one hair on the Rockingham glove did appear to be forcibly removed. It's approximately 12 inches long and was broken at the proximal end, or at the end nearest the point of attachment, near the skin. The hairs from Ronald Goldman's shirt, which was my Q23, they were about 35 forcibly removed hairs exhibiting the same microscopic characteristics as those of Nicole Brown Simpson.
And what about the hairs that were on the Bundy glove? What did those hairs look like?
They were fragments. Actually, it was a treated head hair fragment.
And when you say fragments, what does that mean?
Well, is a portion of hair. There was no root present on the hair.
What about the hairs that could have come from Nicole Brown that you found on Ron Goldman's pants and knit hat? What did those hairs look like?
They were fragmentary as well, under 3.5 inches. No roots were present on any of these.
Were they naturally shed?
No. A naturally shed hair will have a root that has a club shape, like I previously testified to, and none of these had roots of that condition.
None of these, in other words, none of the hairs that could have come from Nicole Brown had the appearance, roots the appearance of which would show that they were naturally shed?
They did not.
Did you prepare a chart depicting the microscopic appearance of the hairs, the known head hairs of Nicole Brown and the hairs that you determined could have come from her from the evidence items?
I did.
Mr. Fertlow, we may need to raise that up.
Just use that as high as this particular easel goes. I can't swap out easels.
Let's swap easels. Because the bottom is obstructed by the projector here.
Don't forget about juror number 7. Maybe they could just put a mirror in the courtroom, right in front of the boards, so that juror number 7 could just look in the mirror, see everything reversed, come up with a different hung jury. Never mind. Never mind.
Back as far as you can so you don't block the witness.
Zach, I'm sitting here praying this short will die quickly because I have a video dropping at 10 o'clock and my one short killed my video the one day because it was going crazy and then took all my views. I'm waiting for this stupid short to die. Die, short, die. Hurry up.
Can you see that? All right, 165, can you see that? Yes, sir. Thank you. Ms. Clark.
That would be helpful if they all had the evidence right in front of them.
All of the hairs on Nicole Brown's known exemplar that you determined to exhibit the same microscopic characteristics as the hair recovered from the evidence in this case?
I don't believe all of the hairs, the question hairs, were photographed and that are represented on that board.
Is this a representative sample of what you saw under the microscope?
It is, yes.
If you would, sir, could you please step down and explain to the jury what it is that you saw that was significant to you, that caused you to come to the conclusion you did with respect to the hairs that are depicted on this board that I asked if you mark people 476?
476.
Okay, with respect to question hair number 1, it was a 12-inch long hair that was recovered from identified as recovered from the Rockingham glove. I photographed an area of the known, which was K4, a known sample number 4 from Nicole Brown Simpson, and an area from the Rockingham glove, again, that being Q1. Always keep in mind that these photographs are about 250 magnification, and I'm just representing an area that appeared to me to be similar microscopically. I'm not trying to do an entire hair examination for you, I'm just trying to represent what the area that I saw that exhibited the same characteristics. The hair also appeared to be lighter in certain areas. Another hair from the Rockingham glove had some coloration to it, or bleaching, or something that altered the color and made it lighter. So that's another hair that was recovered from the Rockingham glove. 7B was recovered from the Bundy glove. Again, that was, I believe, about 6 inches long or so, and it did not have root. As you can see, there's a range of color, as people have, depending on the hairs that you're attempting to compare. K4 is an area that has been very lightened, and again, artificially lightened hair that was recovered. This is the same hair, an area of one portion of the hair and the area of the hair which is further out nearest to the tip. This known sample was compared with Q23, and again, I mentioned there were about 35 hairs to compare it to, but this is just one of the hairs. The last photograph depicts the condition of the roots that were present in both the known sample and the question sample. Again, this just indicating how a hair would look if it's been forcibly removed. The reddish substance that you see appears to be blood.
Now, you earlier spoke to us about the range of characteristics that you'll find on the head of any individual. Do these hairs that you photograph here, from the known sample of Ms. Brown, exhibit that range of characteristics you spoke of?
Yes, you can see that there is a range, that not all hairs are all duplicates of each other, that some hairs are lighter, some hairs are darker, some hairs have medulation, some hairs don't. It just depends upon the range of characteristics of that individual. And here you see that an area of the hair that probably was down a little bit further near the base was a little bit darker, whereas some hairs were lighter in certain portions of the hair. This piece of hair that was recovered from, identified as coming from the Rockingham glove, would have been probably a more distal portion, out towards the tip, as opposed to a full-length hair, which would indicate a darker portion of the hair. The same thing with the hair fragment that came from the Bundy glove. It's probably a distal portion, as opposed to something that's nearer to the base of the hair.
When you say the base of the hair, what end is that?
That's proximal, nearest to the skin.
To the scalp?
That's right, where it's attached.
Now, you indicated earlier in your testimony that when you do a hair examination, you look through the whole length of the hair, the entire hair, correct?
Right, you look through everything that you have to compare. Some hairs may be 3.5 or less, some hairs may be 12 inches, like in this particular case. So that when the comparison process involves looking for hairs in the known sample that compare both by the length and how the characteristics change along the length, and also doing regional type comparisons if you have portions of hair. That is, if a hair portion, if the question is, could this portion of hair have come from that individual, the comparison would be with areas of the hair that have the same microscopic characteristics, which might be out at the end of the hair. So the comparison is based on what you have.
Now, you indicated that this was like 250 times magnification.
It's approximately 250 times, yes.
So, do these photographs depict the entire length of the hair that you saw when you performed your examinations?
No, for instance, if I wanted to photograph serial photographs of each section of that hair, it would be like 25 feet long. So, we don't do that. We just try to take an area that appears to represent the conclusion that's being drawn from that comparison.
Okay, you only photographed, I think, on this board, 2 of the hairs you determined to exhibit the same microscopic characteristics as Nicole Brown on the Rockingham glove. In this board, they're both labeled Q1 on the far left as I face it.
That's right.
How many hairs did you actually find on the Rockingham glove that exhibited the same microscopic characteristics as the hairs of Nicole Brown?
I believe there were 4 that were recovered from that item.
Can you describe what those hairs on the Rockingham glove look like?
As I said, the one it was approximately 12 inches long, and it was broken at the proximal end, or nearest to where the hair attaches itself to the scalp. The others were fragments. Again, I don't recall the exact length, but they were shorter fragments.
Is there any significance to the fact, sir, that you found the same microscopic characteristics in several question hairs, that is, hairs collected from the evidence in this case?
I haven't been paying attention for the last 30 minutes.
Well, the more association...
Did I miss anything important? Did anybody here? Was anybody paying attention for the last 30 minutes? Because I missed it completely.
...that are made between hairs that vary a little bit in characteristics, the more significant that association is, because you're associating different hairs that also appear in the known sample.
How many hairs did you find that exhibited the same microscopic characteristics as those of Nicole Brown on the Bundy glove?
There was 1.
And how many hairs did you find on Mr. Goldman's shirt that exhibited the same microscopic characteristics as those of Nicole Brown?
There were approximately 35 on the shirt.
Were they forcibly removed or naturally shed?
As I said, they were forcibly removed.
What, in your experience, sir, could account for the hairs that exhibited the same microscopic characteristics of those of Nicole Brown on Ron Goldman's shirt?
Either a primary or a secondary transfer. Either came there directly from the head of Nicole Brown Simpson, or they were transported there as a secondary transfer.
That's right. It could have been 7.9, 8.0, or 8.1. Yep.
Pose for you a hypothetical, if I may. You indicated that the finding of hairs that exhibited the same microscopic characteristics as those of Nicole Brown on Ron Goldman's shirt could be there by primary or secondary transfer. If you would assume the following events, sir, that the killer pulled back Nicole's head with his left hand, in order to slit her throat with his right hand, and then went over to Ron Goldman for a final attack, touching him in the process with the hand that held Nicole's hair by the head, could that account for the hairs that you found on Ron Goldman's shirt?
He hasn't qualified in this area.
Yes, that could account for the presence of those hairs.
You also indicated that you found more hairs that exhibited the same
I just want
microscopic
OJ to get up and say,
characteristics
no, that's not how I did it.
on the
I
Rockingham
did it like
glove
this.
than on the Bundy glove, correct?
That's correct.
Now, are you aware that the Bundy glove was found at the scene of the crime, of the murder,
I am, yes.
and that the Rockingham glove was found at the defendant's residence?
Okay, wait.
Yes.
What?
I am trying to think back over this entire trial that the prosecution is about to rest on. And Marcia Clark being the head prosecutor on the team. And I'm trying to think back of one other time during this whole time she said the words that Nicole had her throat slit. I know other people have said it when they were talking to the medical examiner and other people. But I'm trying to remember one time the lead prosecutor in the murder trial spoke about the murder. Specifically, the murder. And I still don't know if she's ever uttered the words that Ron was stabbed. And they're almost done.
What does that finding indicate to you based on your experience with respect to how long each of those gloves remained on the hands of the killer during the murders?
Sustain.
You indicated earlier, sir, that with respect to fibers, they move freely, more freely than hairs, correct?
Yes, they do transfer more easily.
Let me pose this to you in the form of a hypothetical. If the killer, while wearing both gloves, launched an initial attack on Nicole by knocking her unconscious, having very limited contact with her in that initial contact, and then subsequently lost the Bundy glove early in the struggle with Ron Goldman, could that account for the fact that you found more of the hairs that exhibited the same microscopic characteristics as Nicole Brown's hair on the Rockingham glove than on the Bundy glove?
Sustain. It's not appropriate hypothetical. Let me see counsel sidebar. Without reporting.
That's fine, Judge. Go to your sidebar. It's been 2 hours. It's time for me to stop. Anyway, I mean, I would have liked 30 more seconds, but that's not what you're giving me. I'm going to fast forward it to the next part just so that tomorrow morning we're ready and we don't have to. No, I'm not. I'm just going to let it play because it's too tiny. All right, guys. Thank you for coming out today. Thank you. Zach, go to Dutch Wonderland. It's going to be a good day for Dutch Wonderland. It's a perfect day for Dutch Wonderland. I shall see you all again very, very soon. Please behave. Okay? Thank you so much, guys. Thank you. Bye. I know, Bobby. I know.